Hi, everyone, and thank you so much for joining us today for E2 webinar about the E2 visa options where the investment amount is low and other risky cases. Just by way of introduction, my name is Hugues Plessis, and I am an associate at Scott Legal PC. I'm joined today by LeGrand, the managing attorney at Scott Legal. And as I was saying, we're going to go over some risky cases for E2, some of the presentation about the E2 visa as well, and then you can also ask some questions in the chat and the Q&A option, and we'll go over the questions at the end of the presentation. As some of you may know, our firm was founded by Ian Scott on an E2 visa. So, we know exactly what you're going through at the moment if you're thinking about applying for an E2 visa. Scott Legal is a full-service immigration law firm, and we assist clients with a broad range of U.S. immigration matters, including family-based, employment-based, humanitarian cases as well. However, we do focus on E2 visas, and we process a high volume of them each year. Just a few items before we go through the presentation. So this webinar is part of a series of webinars that we conduct twice a week. At the end of today's webinar, we will send you today's presentation, an E2 guide with a lot of very useful information about the E2 visa, and a link to sign up to additional webinars as well, and access this webinar because it is recorded. This webinar will also be available on our YouTube channel. We have a lot of very good short form and long form content on that YouTube channel, so I would highly recommend that you check it out. If you want some more information about the E2, but we also have webinars about the TN, visa, O1, etc. If you have any questions during the webinar, as I was saying, please feel free to ask those questions in the chat or in the Q&A, and then we'll go over all the questions at the end of the presentation, and we will answer them. All right, so let's start with today's presentation on E2 visa options where the investment amount is low and other risky cases. So first off, if we can go, Kelly, over the first slide for the requirements. I just wanted to go through the requirements, just make sure that we're, aware of what an applicant needs to meet in terms of requirements to actually qualify for an E2 visa. So first off here, as you can see on the slides, is that to qualify for an E2, you must be a national of a treaty country. There is actually a list of all the treaty countries on the Department of State website, so I would highly recommend that you just go onto Google, Department of State website, check the list, and you'll see there all the countries that have signed a treaty of commerce with the United States. That list is updated from time to time. Israel was added recently, and then some countries that would not be included, for example, would be Russia, China, and India. So you can go through the list, making sure that you actually have a passport from a country that has signed a treaty with the US. And that's also something I wanted to point out. This is very important. Country of birth for the purpose of the E2 does not matter. What matters is whether or not you have a passport from a treaty country. So that's the first sort of baseline requirement that you must meet. And then second requirement here is that the applicant for the E2 must own at least 50% of the US business. So when you're going to start a US business, or you're going to buy a business in the US for the purpose of the E2, you must make sure that as the applicant, you own at least 50% of that business. And then third requirement here, really important, because it is sort of the basis for the E2, is about the investment. The E2 is an investment-based visa, and there are some requirements that you need to meet in order for the investment to qualify for the E2. So first off here, as you can see, the investment and the funds must be at risk. That means that you have to have actually spent the money. Idle cash, just money sitting on a bank in a bank account would not qualify. You need to have actually spent money on expenditures that are required to set up the business, or you've actually spent the money to buy the business in the US. That's really important, this at-risk notion. There is also some requirements about the source of funds. Essentially, the funds must come from a legitimate source, but depending on whether or not you're going to apply for the E2 within the US with the Immigration Services, USCIS, or if you're applying at a consular post abroad, you will have to document the source of funds a little bit differently. But regardless, immigration officials will always require that you provide documentation supporting where the funds that you are investing in the US are coming from. Could be, we've listed here a few examples of source of funds. Could be personal savings from employment, could be a gift from a family member, for example, sale of a house, a loan as well. There are some, very specific requirements for loans. Essentially, if the loan is secured, meaning that it is secured by the assets of the E2 business, then it will not be included and cannot be a source of funds. So you have to do some analysis there. But yeah, all those are usually what we see in terms of source of funds. The investment must be at risk. It must come from a legitimate source, but also must be substantial. So I will go a little bit later on during the presentation about what substantial means in the context of an E2. But the first thing I wanted to mention here, and that's a question that we get a lot, is whether or not there is a minimum amount to qualify for an E2, and the answer is no. There's no set minimum amount in the regulations. So you'll have to go through the substantial test, and whether or not the government officials will consider the investment substantial is based on a test that I will provide more information later on. So there is no set minimum amount to qualify for the E2. What we usually say is that the investment must be sufficient to make the expenditures necessary to set up the business and make it operational, essentially. There is also some information here about the difference between the investment when starting a business and purchasing a business, and what that entails. What I wanted to mention here is an option that's really interesting when you're buying a business is the escrow. That means that you can have the money in escrow for the business to be bought, and the sole condition of the money being released would be for the E2 visa applicant to have the visa approved. That's a very good way of protecting yourself as the E2 applicant. Fourth requirement that you can see on your screen here is about marginality. So this is really important for the E2, for the initial E2, but also when you're going to renew the visa, if that's something you're interested in. Marginality means that the E2 business in the US must not only support, but generate revenue not only to support the E2 applicant and their family, but also US employees. So that's something that we usually satisfy in the initial application by providing a strong business plan. And in that business plan, we would include a hiring plan to show that the business in the US will hire employees over the course of the next 5 years. What we recommend in terms of number of employees, because that's also a question we get a lot, is to have at least 3 to 4 full-time employees within the 5 years of operation. So that's included in the business plan. That's part of the application process and the application package that you're gonna bring to your appointment, send to the consulate, or file with USCIS. Next requirement here on the list, the fifth requirement, is that the E2 business must be real and operating. This essentially means that the investor has completed all the required steps for the business to be set up and operating, meaning that if a lease is needed, if business premises have been secured, whether or not you have the correct licenses and necessary licenses to operate in the US, with the FDA, for example. So everything must have been set up for the business to be running and operating once the E2 visa applicant gets to the US. For that real and operating requirement, we can also provide evidence that the business is already generating revenue with contracts with clients and customers, for example, but also letters of intent of maybe future customers and clients saying that they are intending on working with the E2 business, getting buying their services or their products. And then sixth requirement here is that the E2 applicant will solely develop and direct the E2 enterprise. So, when you get an E2 for a specific business in the US, you have to come in the US and work business to operate it, cannot do, be employed by someone else. So that's really important. And we also need to show that the applicant is well positioned to direct and operate the business in the US. That's usually based on a track record of success outside of the US in a similar business, for example. Could be degree as well, education, that sort of thing. And then the last item here, which shall not be overlooked, is that you have to have the intent to return home after the E2 visa expires, and that's really important because the E2 is a non-immigrant visa, so it is not a green card. It's not permanent, authorization to work in the US. It's a temporary work authorization, and I will go a little bit later on during this presentation about duration of stay in the US, the visa validity and everything. But that's also something we include in E2 application packages, is the declaration from the E2 applicant saying that they intend to return to a home country after the visa is expired. We can go to the next slide here. So that's for the requirement. Thank you, Kelly. So that's for the requirements, and I want to dive a little bit more into those requirements, just provide some information about, first off, that first item I was mentioning is being, a national of a treaty country. So I mentioned a little bit early on that, you have to have a passport from that country, and country of birth does not, is not a factor for the E2. That's something that's really important for some people, because you might have dual nationality, for example. It can be a citizen of a country that's not in the list, and then a citizen of a country that's in the list, and so you will be able to use that citizenship to apply for the E2 and that passport. That's usually a good option. I'm thinking of Brazil, for example. If you are a dual national of Brazil and Italy, then you will be able to apply with your Italian passport. So good option there for dual nationals. And then, as I was saying before, it's on the presentation here, is about the non-immigrant intent as well. Something I already mentioned that's really important. Showing that you have ties to your home country, that you intend to depart. This is also something that is important in the case of a dual national. Something that you might have to think about a little bit more. In terms of the countries that are listed, again, there's a list, but in every continent you have countries, so that's for you to check on the list. And then about the validity of the visa as well, we're including here some information, but I wanted to provide a little bit more because I know this is confusing, and we get a lot of questions about duration of the visa and duration of the status in the US. So when we say that when we mention the term visa, we actually mean the physical visa that you get in your passport when you apply at the US consulate abroad. So when you're going to apply if you apply for the E2 at the US consulate, you submit your application, and then you will get a physical visa in your passport. And that visa will be valid for a period that's determined by the visa reciprocity schedule. So the reciprocity schedule is something that's published by the Department of State, and essentially lists the validity of each visa in each classification, depending on your country of citizenship and the passport that you have. For the E2 visas, depending on the passport you're applying with, the visa could be valid for 3 months up to 5 years. For example, for Canadian citizens, the visa is valid for 5 years. However, that does not mean that your status in the US will be valid either for 3 months or 5 years. That's the difference between a visa and a status. So if you get a visa that's valid for 3 months, for example, an E2 visa that's valid for 3 months, and then you enter the US, you will be allowed to stay in the US on an E2 status for up to 2 years before you have to renew or extend. But that's the same thing if you have a 5-year visa as well. You enter the US, and the initial period of stay for the E2 is always going to be 2 years, regardless of the visa validity. So I know this is a little bit confusing, and that's also something you can check for yourself. The reciprocity schedule is published online on the Department of State's website. You just go there, check your country, check the classification itself, the E2, and then you'll see whether or not, you'll see the duration of the visa. So there's a little bit of a strategy involved with that, depending on the duration of the visa, when you want to extend, whether or not you want to maybe apply from within the US, to extend your E-2 status at the end of the 2 years, whether or not you want to maybe apply for a visa again at the consulate because you need a new visa. So that's something you need to be aware of before starting the process, so that you can strategize a little bit, and then also make sure that you have a valid visa when you're re-entering the US after international travels. We have a lot of clients with issues with that, so that's something that you need to factor in for sure. Here, just on the slide as well, a quick note about purchasing an existing business or starting a business in the US. I've already provided some information on that, but the two options are possible, with, of course, the difference between the expenditures and what the investment will look like in the documentation as well. And I will provide a little bit more information on the next slide. Actually, if we can move on to how much investment is enough for the E2, because I know this is a very common question we get. And at the start of the presentation, I was saying that there is no set dollar amount, and that's true. We're saying here there is no minimum in the regulations. However, the investment must be substantial. Whether the investment is substantial will depend on the business. And for example, if you are setting up a consulting business in the US, a small consulting firm in the US, you might not have to invest a lot of money compared to if you are setting up a restaurant, for example, or a grocery store or a manufacturing. The expenditures will definitely be different, and what will be considered substantial for the E2 will also look very different. So the government, what they do for the substantial requirement is they actually are performing a test, a proportionality test, to gauge whether or not the investment is substantial. And essentially that proportionality test boils down to the smaller the total cost needed to set up or purchase a business, the higher the proportion of this cost must be spent. So I'm just going to give you an example because I think it's easier to understand that way. So for a small consulting company, as I was saying before, if that company requires $80,000 to be set up, then in that case, the investment will be considered substantial by the US government if you have spent at least close to or the 100% of the $80,000 that are required to set up the company. However, in comparison, if you are investing in a $100 million company in the US, then if you can only spend 10% of those $100 million, then that would be also considered substantial by the US government. So you see, it depends on the type of business, depend on how much money it needs to be invested in that business for the proportionality test. We can get some documentation about that as well. We're listing here CPA letter, business articles as well to support that proportionality and making sure that the US government understands that you've spent what's needed for the business to be set up. Essentially, again, what boils down to is a smaller proportion is expected to meet the substantial requirement based on the higher value of the business. If it is a business that needs a little bit less investment or low investment, then the proportion of that investment must be higher. When an applicant buys a business, there's a different test there, and it's listed on there. It's not about whether or not you've invested 100% or a different proportionality for the investment, but it's rather about comparing the purchase price and the fair market value. That's what the government will do when you purchase a business compared to investing and starting up a business. So if the applicant bought the business on the open market, they likely paid the fair market value. So that's usually pretty straightforward. We've seen issues when E2 applicants are actually buying businesses from family members, for example. In that case, it's a good idea to get a CPA letter, for example, confirming that the price the applicant paid is actually the fair market value of the business. We can go to the next slide, Kelly, about because I wanna touch base on the strategy to deal with low dollar amount, because this is something that we get a lot as well. After the question, is that enough? then they will definitely, clients will want to know more what they can do about, when they are investing a lower amount that's usually the case for E2 cases, and what we can do to sort of counter the low amount invested to start up a business. So what we can do, and we listed some examples here of the strategies, but the first thing that we would do is stress all the factors of the application. For example, we can provide stronger evidence that the business is real and operating by providing letters of intent from future customers and clients in the US saying that yes, they plan on hiring the E2 consulting firm, for example, or buy the products that the E2 business will sell in the US. So you can get letters from future customers and clients showing that they're actually going to give you business in the US, and that's going to be definitely, that's going to strengthen the E2 application. You can also have contracts that are already lined up, already signed with clients in the US or elsewhere, but with the US entity. You can also show that you have a track record of success in the field. For example, if you're opening, a company in a specific field in the US, you want to set up that company, then you can show that you've actually been successful in your home country with similar companies, or with in the same field, or with selling the same products or the same services. So that's usually something we would stress in the application, showing that track record of success. And then experience as well, experience running businesses and the specific business that you're going to run in the US too. Whether or not the US entity also has employees, that's obviously very good, for the application, and it will definitely help if you have a lower amount invested. You can also obtain letters from organizations within the area of the business operating. For example, here we're listing the Chamber of Commerce, so that's usually good as well. And then draft a strong business plan. As I was saying before, the business plan is part of the application, shows that you have a plan for the growth of the company in terms of the financials, obviously, but also a hiring plan. So drafting a strong business plan definitely helps, especially if you're investing a lower amount. And then you can also, sort of lean a little bit more about the type of business that you're going to open in the US, depending on what you will do. But you can show that, it's a field in the US, maybe you're not going to have a lot of competitors, for example, or you are bringing something new to the table, a new product, or, you have patents, for example, for a new product, that could be something that we want to add to the application to strengthen it if the amount of the invested is a little bit lower than what they usually see. And in terms of investment, we can move on to the next slide, because it's about those common E2 visa expenditures. So we've included here a list of what we see on a regular basis, in terms of what's going to be acceptable and strong expenditures for an E2 business. So obviously, website, it's usually a good indication that the business will be up and running, that they have a website in the US. That also can play a role in showing that the E2 company is real and operating, having website where you can, order products, or, schedule some time to discuss if you're a consulting firm, for example, that's all good. Of course, commercial lease, that's a big one. For the lease, you can include the deposit, for example, but you can also sometimes, you can actually pay rent in advance. So you can include the rent for next few months or the full year, for example, coming up. So again, that sort of ties into money being at risk. You have to spend the money. So just showing that you have a commercial lease signed, it's not going to be enough. You need to show that you've paid the deposit and also maybe pay the rent in advance. Of course, equipment, that's also something that we usually include. Computer equipment, for example, laptops, tablets, phones, phone plans as well. That's something that we can definitely include and show that the company will actually be up and running once the E2 visa applicant gets to the US. Other good expenditures would include marketing as well. Marketing and advertising. We can show that you've bought some ads on Facebook maybe, or you've done some marketing, press release, that sort of thing. So that we can definitely include that, and that's something that we do on a day-to-day basis. Other fees that maybe you wouldn't think about, but legal fees as well, set up the business, but also legal assistance for the E-2. Those fees can also be included. You can also include accounting services related fees, so that's usually a good one as well. Licensing fees, it's listed there as well. If you need a license for the business and you have to pay fees for that, you can definitely include it. Another very good one would be payroll related fees. If you have employees in the US, you can, any expenses related to the payroll can be included, but also, of course, the salaries. That's something that we would definitely include. Training, we're listing it here, but it is very, it's a little bit tricky. So I would highly recommend that, you consult with an attorney about including training related fees. It has to be very specific. It has to be related to the E-2 company. It cannot be, broad and general. So a good one, but I would recommend being careful with that one. And then software as well, anything related to the business being up and running in terms of technology would also be definitely included. And then what are the examples of bad or weak expenses? Because this is a list of definitely good, strong expenses that we would list. But on the next slide, Kelly, we can move on to expenditures that we would not include. And those are also some expenditures that we see on a day-to-day basis, clients asking for whether or not they can be included. So that would be the big one here is the first listed would be travel-related expenses. So if you're traveling from your home country to the US to set up the business, flight tickets, but also accommodation-related fees or expenses. If you're staying in a hotel to be able to set up the business, etc., that will not be included. That's usually weak, and it's not going to be, regarded by the government as something that would support an E-2. Could also be meals with clients as well. That's not going to be included. Transportation as well to and from business meetings. Entertainment, that's also a big one that's not included there. The two last items here, I just want to spend a little bit more time on. And the first one will be expenses directly reimbursed by client or customers. So that's something that we see as well. So if you're pre-purchasing products or services that will eventually be resold to the customers, then you can't include that reimbursement costs. And also the last one here, expenses paid to related parties. So for example, if your brother is designing the website for your E-2 business and you're paying him a high fee, a very high fee compared to what usually you would pay a website designer, then that would definitely be a red flag for the government, and they may consider that this is not a bona fide expenditure. So that's something you need to be careful about as well. And again, you can list all the expenditures, and then the attorney will definitely review and make sure that only those that are strong and support the E-2 will be included. I think that was it in terms of expenditures and expenses for the E-2 visa and the investment. I will now turn it over to Kelly to walk us through some of the other questions that we get on a regular basis and that come up in other risky E-2 cases.
Thank you. Perfect. So we're going to talk about kind of some very, specific examples that we often see for kind of risky types of E-2 cases. One business that's very, popular that we do are kind of consulting businesses. And theoretically, you need a very low, investment to start a consulting business. It is a very common, question that we get where people will say, well, I have a laptop, I have my knowledge, I don't need to spend any money. I don't need an office. I can just do my work from my house. And while that is true, for many consultants, ultimately, in order to be granted the E-2 visa, you do have to make a substantial investment. It is an investor visa. And so it is about figuring out, how can you invest enough to meet the requirement to show you've made a substantial investment, that you're committed to successfully operating the enterprise, while also not, just throwing money away. So usually one of the things we do is recommend that people try to, think about what expenses would you have over the first 1 or 2 years of your company And can you bring any of those expenses forward to be startup expenses? So for example, for office space, sometimes you can prepay for, 12 months or 6 months. Unfortunately, kind of signing a contract that commits you to pay each month, that in itself is not going to count as kind of irrevocably committed for the E-2 requirements. But if you do agree with your landlord that you'll maybe pay the deposit and then prepay a certain amount, you could include that. For equipment, let's say that you plan to hire 2 employees by the end of the year, but you would wait and not purchase computers or other equipment for them until they're actually hired. Perhaps you purchase that now because you know that that's an expense that you're absolutely going to have. Similarly, you could invest more in marketing. So maybe in a non E2 scenario, maybe you would just start out with your contacts and calling people but perhaps, because it's an expenditure you're going to do down the road anyway, maybe you pay for kind of a more expensive website. Maybe you invest in kind of some discussing with a PR agency or kind of doing some more marketing to get yourself out there, especially because there's so many consulting businesses. It can be something where they are interested to know, how are you going to differentiate yourself? Do you actually have an interest in your services? So it is always important to have a developed marketing plan. Similarly, you could hire employees. So another very common kind of issue with consulting businesses is their concern that someone's going to come in and be a solo consultant. And that's not what the E2 is for. It's really for entrepreneurs who are going to develop and direct a business, but not operate themselves doing the actual skilled labor. So they do want to make sure that the company is going to support more than just the investor and their family, and hire workers in the US. So hiring employees and anything you pay to kind of, if you actually pay the employee, maybe they're doing some of your office startup work, or handling initial proposals from clients until you get your E2, or maybe you haven't paid them yet, but you've paid expenses like getting a payroll provider set up, or getting workman's comp or health insurance set up. Anything you pay for either paying the employees or those ancillary expenses can be included as part of your investment. You do want to spend also over a large number of categories. It's not a good strategy for an E2 to say, well, look, I've spent $40,000 on a really expensive website, and then I bought some pens. And I have a laptop, so those types of expenditures, even though you may get to, 40, 50,000 with that, that's really not going to work well for an E2, because again, the standard is, have you invested everything necessary to get the business to the point of being operational? So you want to think about realistically, what does any type of business need, right? It's going to need, not every business needs office space these days, and it's not a requirement, but it is generally very helpful for many things, such as having, a commercial business address where you're going to receive mail. If you do have employees, a place where they can go if you're going to meet clients, a place you can meet clients. So all of those things are important. You want to be thinking about, what do I actually need to run this business? Do I need a software subscription? Are there any kind of market research or trade publications I can subscribe to that would be helpful or useful? So you do want to kind of be thinking about that holistically. So you're not thinking about, I just need to get to this number. The actual things you're spending money on do matter, and should make sense in light of the type of business that you're starting. All right, so let's talk about another kind of high risk, E2 type of case, and that is an E2 for a real estate company. So, part of the reason this is high risk is that there are many applicants who think, well, I can purchase a property in the United States, I can purchase it with a company, and that will be a very large investment. So, and I'll visit it or I'll rent it out and I'll get rental income. Is that going to work for an E2? And it's such a kind of common issue that comes up that even many consulates in their Q&A section have a specific question that addresses this, that says, no, you cannot purchase, a piece of property and have that work for an E2, because it does need to be a real and operating business that can support employees, that the person's going to develop and direct in the US. So the challenge here often is to show this is going to be a real and operating business. This is not just a speculative investment where you're collecting passive real estate income. You have to show that this is actually a type of business where you'll be able to hire employees. That being said, despite these risks, we do frequently do real estate, E2s. Here are some things that have worked. So a real estate brokerage firm, a property management company. So if it's a situation, maybe you have purchased your own residence or property, but then maybe you get contracts to manage the the properties of other independent property owners. That can often work. A real estate renovation or construction business, so fixing up homes, that's a very viable E2. House flipping, it can only work if it's really on a large scale. So we've done it in the past, for example, for a client who had a portfolio of 30 to 40 homes that they were working on flipping. As part of that real estate portfolio, there was, a lot of kind of employment activity because there was lots that needed to be done, both for the renovation of the homes, the selling of the homes, and then there was some property management as well. So there are very viable real estate ideas, but you do need to keep in mind kind of these concerns the officer may have. Another concern that comes up a lot with real estate is kind of licensing. So, for example, if you're doing kind of a brokerage or you're going to, sell property, very often you do need licensing. Or if you're going to be doing renovation or construction, often you need a general contractor, or you need to associate with a business that has a contractor's license. So you do want to be very aware of kind of both the federal and state and local requirements for this type of business. And if it's the type of thing where, well, you're not going to be able to get the proper license until you get the E2 because you need a social security number, you may need to create kind of a business partnership with another company that maybe does have that license to give yourself the ability to kind of run the company in the meantime. So, and it is something that if you apply for a change of status within the US, they're very, very kind of, aware of this issue and always asking questions about whether you have all the proper licenses. They're less focused on this at the consulate, but for this type of E2 visa, for a real estate E2 visa, it is something they do ask about. So you always want to keep that in mind. All right. So another type of business, that's kind of a high risk business for E2s is an equity trading company. And it has a lot of the same concerns that we just talked about for real estate. So again, sometimes people will just kind of put a stock portfolio, in an LLC as opposed to an individual. And that in itself is not going to be active enough for an E2. Similarly, if you're just kind of managing, money for your, immediate circle of friends or immediate family, that also is not going to look, like it's going to be the type of real and operating business. It's going to support workers in the US. And then similar to real estate, it is a highly regulated industry. So if you're doing certain types of trading, you do need to have certain licenses. If you're doing something like opening a hedge fund, often there's going to be kind of multiple entities that are related to that. You need to really work with your attorney to figure out, which entity is going to be the one applying for the E2, which one is going to, have an operational, like expenses, which one's going to take in the revenue, which one's going to hold the employees. So you do want to kind of understand all of that to make sure that you can explain it to the officer so they feel confident, that this is really going to be a real and operating business. All right, let's talk a little bit about reasons for E2 denials. So, one reason is low investment amount. So, as we've kind of talked about earlier, there is no minimum amount in the law. There is nothing that says if you invest X number, then this will work. It is a proportionality test, and it is based on the type of business that you're starting. So there's arguments you can certainly make as to why service-based businesses have very, very low startup costs. But you also want to be thinking about where you're applying. So there are certain venues that are more receptive to low investment amounts and others that are not. For example, there are certain consulates, like in Asia, for example, that they're most used to seeing very large multinational companies who perhaps are sending, hundreds or thousands of E2 employees. For those consulates, when they see kind of a small business owner applying, that's kind of a less familiar application to them, and they may be harder on that. They may be less willing to accept a lower investment amount. There are also consulates that are, work more frequently with smaller entrepreneurs and therefore kind of are more amenable to certain arguments about what counts as a substantial investment amount. If you apply for a change of status with U.S. Citizenship and Immigration Services, they in particular at this time are quite receptive to lower investment amounts, much lower than we see kind of accepted at consulates. Another reason for E2 denial, nature of the business. So as we just discussed, there's certain types of businesses that are more high risk, for the E2. If you're starting kind of a very speculative business, and they don't feel that kind of the investment is sufficient, or that you have the experience, or that especially for consultants, the concern, are you just going to come in and act as a solo consultant? Or for real estate, are you just going to collect, passive rental income? Those types of things can be a concern as well. Another reason may be filing location, venue. So as I was just discussing, there are consulates and locations that are kind of more or less receptive to E-2 applications. There's also consulates that are more or less aware of the E-2. So some consulates process, hundreds of E-2s every month, and some process 2. So sometimes actually it can be, in your favor, and sometimes it can work against you in terms of whether you're applying at a consulate that's either very well versed on the E-2 or it really doesn't know kind of what's going on. But you do want to kind of discuss that strategically. If you do have options about where to apply, you would want to think about that, because it can make a huge difference, in whether you're approved or not. Something else that can come up, these next 2 bullet points are kind of related. So, and they both go back to the E-2 requirement of marginality. Is the business going to support more than just the investor and their family? Does it have the ability to make this substantial economic contribution? So if you've run a business in your home country for many years and it's kind of stayed a small business and you've never hired employees, or maybe you had your spouse helping you, something like that, that can often read very negatively to the consular officer. They may look at if you're applying without any employees and just based on a 5-year business plan, they may look at that and think, well, we don't really believe you. We have this history of you running a similar business and you never did hire anyone. So for those types of cases where you do have that history, it can be very favorable to actually hire someone before you apply. Although it's not required, it can really help those types of cases because you're just addressing that concern at the outset. So that, the other, more general concern, will this business create jobs for U.S. workers? If you have a history of running a business that's hired many people, then, you can certainly mention that in the application. But generally for certain types of cases, like the high risk ones we've just discussed, there is a bit more concern about this. Are you going to create jobs? So that's where a business plan is very important. And if you have some of these other negative factors, maybe you even consider hiring an employee, because it's a very positive thing for your application for multiple things, for marginality, to show the business is, going to start operating very soon, as well as increasing your investment amount based on anything you pay to the employee, and, any kind of ancillary expenses you pay because you have that employee. Another thing that can come up is, issues with the adjudicating officer. Consular officers are human beings. They have kind of, varying levels of training. They have good days, they have bad days. They're getting through hundreds of visa applications often in one day and have very little time in which to do that. So it is a situation where you do want to prepare with your attorney for the interview to understand what that's going to look like. So you're not, kind of flustered or surprised maybe when they cut you off, again, because interviews are often 5 to 10 minutes maximum. So if you do have an officer where you feel, that they were really unfair or they were really hostile, you always want to be as polite as possible, because they have complete discretion over whether to grant or deny the visa. And then afterwards, you want to kind of, as soon as possible, write down everything that happened at the interview and then share that with your attorney, so you can come up with a strategy to determine if you want to, reapply. It is not something that they promise, but most consulates will try to give you a different officer if you do reapply. Another reason for denial, maybe you didn't meet the requirements at the time of filing. So many people will maybe try to file themselves, or maybe file with, attorneys that maybe aren't as familiar with the requirements. We've had a few people that come to us and said, I spent $2,000. I had $98,000 in a business bank account. That should be sufficient. Why didn't it work? At that point, $2,000, it's not a substantial amount, even for USCIS, which, has very lax standard for what counts as substantial. There's just not a scenario in which $2,000 is going to work, for an E-2 application. So we advised him on how to spend money on various relevant expenditures, and then the case was ultimately approved. All right, let's talk about some E-2 adjudication trends. So, the government does kind of regularly post their approval rates. E-2s generally do have quite good approval rates, between 80 to 90%. We have an approval rate around 98%. However, of course, past results do not predict future outcomes. In terms of timelines, some consulates I'll talk about London and Toronto first, and then generally. So London right now, they report a timeline of 60 business days to review the E2 application. And after that, they'll send an email to allow you to schedule your E2 appointment. Usually people can get an interview, within a few weeks after being contacted. That being said, this is just a general timeline they give. We have many cases, especially this year, that have gone outside and gone longer than that 60 business day timeline. It's kind of to give you a basic idea. It's not something that they kind of commit to. And certainly if it goes longer than that, you can follow up with the consulate, but they may just say it's still in process. In Toronto right now, timelines are quite good. You can, submit your application, usually hear back within about 15 business days after you submit. They'll open the appointment, calendar. You'll be able to schedule your appointment. And generally people have been able to get appointments within, maybe 2 to 6 weeks. They're also quite reasonable about expedites. For example, if you were applying, just recently, many people were applying and had, issues with kind of school. Can children attend school? And they were quite, open to kind of hearing those expedite requests. It is always, again, it's always discretionary. It's really based on their, their calendar, their availability, but it's always worth asking. Generally, beyond these two consulates, timelines are all over the place. So there are many, many consulates that do not post their timelines. So the only way to kind of know where they're at a given time is to, speak with colleagues or just continue, to speak with your attorney to try to understand what's going on there. You can also contact the consulate to ask. They won't always tell you. Some are extremely, extremely delayed still from COVID. We're looking at kind of delays of over a year. Some like London and Toronto, Japan, are kind of more back to normal, but unfortunately it is a moving target. So you always want to be thinking about that, thinking about what will you do if the timelines suddenly extend, because unfortunately since COVID, it is not unusual to see review timelines that are kind of maybe even upwards of 6 months or longer than that to get an appointment. Considering USCIS versus the consulate. So with USCIS, what you apply for is either a change of status, or if you're already on an E2, an extension of status. This is not a visa stamp that allows you to travel internationally. It is an approval that permits you to stay in the United States and work, for the E2 company. However, once you leave the United States, you will have to go to a consulate to get a visa stamp before you can re-enter. And the consulate will treat the application as a brand new application. So let's say you applied with USCIS for a change of status. Maybe you invested $30,000 into a service-based company. You got an approval. $30,000, I'd say, is a very, very low investment amount. But then you want to go to a consulate to get a visa stamp. And could be difficult to get that visa stamp without investing more money first, because 30,000 is a very, very low amount. And even though USCIS approved it, the consulate doesn't have to take that into consideration. And in fact, sometimes seems to even view it as a negative, or they don't know what they're talking about. So it doesn't, many times people are confused because if you get an H-1B or an L, and you get that approved with USCIS and you go to a consulate, essentially they should just be approving the visa stamp, that they're not re-adjudicating the merits of the petition. That is not the case for the E2. When you submit for the E2, even if you have a USCIS approval, they are re-adjudicating the merits of the petition and every element of requirements. So they're looking at the investment, deciding if they think it's substantial. So that is really important to know. Consulates, the benefit of going to a consulate is you'll get a visa stamp in your passport that will allow you to travel internationally. Every time you enter on your E2 visa stamp, you're eligible to get 2 years in E2 status. This is true even if you have a 5-year visa stamp. So for example, for Canadian nationals, they get a 5-year visa stamp. Maybe they enter, they're going to get an I-94, that's your status document. That's going to allow you to stay for 2 years. When that I-94 is coming up, you need to leave, and then you can just re-enter with the same valid visa. If you wanted to extend your status in the US, you could, but generally much simpler to just leave and re-enter. As Hugues talked about in the beginning, there are some countries where there is a very short visa stamp time period that's given. So let's say, for example, in Bangladesh, they get 3 months. However, when you enter on that visa, you're not only going to get 3 months in E2 status, you still get 2 years in E2 status. So those are all important things to keep in mind. Kind of things, when you're deciding where to apply, you want to think about kind of some specific considerations based on certain posts. So, each consulate is kind of its own little universe. They do not have kind of one blanket system for how you apply. Each one has their own instructions, their own preferences. There's some that have, page limits of 30 pages, some have 50, some have 100, some have file size. So some say don't include business plans. Some require business plans that are certified by CPAs. That's just to say that they're all very different. They do require, it is the same law that they're, using. That being said, they do all want it in a specific way. And so it is something that you need to kind of discuss, and be aware of when you're thinking about where you're going to apply. All right, some issues that come up with E-2 visas. So, do you have to hire employees before you apply? And the answer is no. Unfortunately, there are some consulates, Taiwan comes to mind, where they had take a different position. The consular officers, will kind of confuse, I think, the real and operating requirement. Again, I think this goes back partly to, mostly seeing businesses that are already operating, either huge businesses sending employees or businesses, where you're purchasing a business that's already operating. That being said, although there are some consular officers that, take this position, it's wrong as a matter of law. It's not a requirement that you have to hire employees before you apply for the E-2 visa. That is nowhere in the regulations. A 5-year business plan is sufficient, and we've had many cases approved, without the people hiring employees. That being said, as discussed previously in the presentation, it is a very positive thing for the application if you can do so. Other things that come up, complicated source and trail of funds. So if you're applying with USCIS, although they will accept much lower investment amounts than consulates, they have a much higher standard for the source and trail of funds. Let's say you're applying with the consulate in Toronto, and you are investing money you've earned, from employment. You could likely include your tax returns and then proof of you transferring that lump sum of money to the E-2 business bank account. If you're applying with USCIS, what they're going to want to see is a dollar for dollar accounting of exactly where that money was earned. So, your payroll coming into your bank account, it being sustained there, or if it was transferred to another account, it being, the proof of it being transferred to that other account, the proof of it, kind of being maintained wherever it was, up through it being, transferred to the E-2 company and spent on E-2 expenditures. So if you do have a very complex source and trail of funds, maybe, the money came from kind of multiple sources or multiple accounts, or you have, gifts or loans, from other people, and they have a very complex source of funds, or they don't want to share, that information with you, you really need to think about that before any money is transferred, because you don't want to be in a situation where you've transferred the money or you spent the money and now you can't use that expenditure. People often will ask, can loans be used for the E-2 investment? And they can, as long as they are personal loans to the investor and are not secured by the E-2 assets. So this comes up a lot with kind of business purchase scenarios where maybe someone's using seller financing. Seller financing can be very problematic for the E-2 because you are, essentially the seller financing is based, it's a loan secured by the assets of the E-2 business. So that does not work. If you're doing that, and a significant percentage of the purchase price is through seller financing, it's very likely they're not going to consider your investment to be substantial, because anything that was, any loan that is, secured by assets of the E-2 business doesn't count as kind of at-risk investment. For gifts, gifts are fine. You can, submit a gift letter, but then you also have to submit all the same documentation you would submit if it was your personal money. So the gift option is not a way to kind of get around the E-2 source of funds requirements. I think sometimes people think, well, I'll just get a gift from my mom and then I just have to submit a gift letter. Unfortunately, that's not the case. You would also need to submit proof that the gift funds have come from a legitimate source, not from criminal activity. So you'd need your mother's tax returns. If you're doing USCIS, you'll need all that, documentation of accumulation of the funds and where they were transferred to. If you're going to a consulate, you can be a bit more high level. Other things, that come up are E-2 visas for 2 investors. So this is possible if they own the company 50-50. That's kind of the arrangement that would need to be done. And then generally as well, it doesn't have to be the exact same amount of money, but usually you want each investor to invest a similar amount of money, right? So if one investor is putting in 100,000 and one's putting in 110,000, this is probably fine. If one investor is putting in 100,000 and the other one is putting in 10,000, this is really not going to work. That investor putting in 10,000 is going to have a really hard time convincing the government that they've invested a substantial amount. In that type of scenario, if the investors are the same nationality, they could consider an E-2 investor and an E-2 employee application. So there are things you can kind of consider, but this is generally a possible arrangement, but definitely some quirks, to discuss with your attorney before you move forward with it. Something else to just keep in mind is that once you get the E-2 visa, many people think, well, I have my E-2 visa, so now I can work in the US. And that's not the case, in the sense that you aren't allowed to just do any work for anyone anywhere. You've been granted the E-2 visa to run the business that you have presented to the consulate. So any substantive changes to the E-2 business that happen after filing, you want to think about that before you make any changes, perhaps discuss with an attorney to avoid accidentally violating your status. So for example, to qualify for the E-2 as an E-2 investor, you have to have 50% ownership at least of the company. If you sell a portion of your company and now it's 70% owned by your US citizen business partner and only 30% owned by you, immediately it's not qualifying as an E-2 company. If you retain operational control, there may be certain arguments you can make, but generally, any changes in ownership, you want to discuss before making them. Similarly, any changes to the type of business, if you were running a restaurant and now you want to dissolve that and start up a wedding photography business, you need approval from the government before you can do that. However, if what you're doing is kind of a natural outgrowth of what you were already doing, like let's say you own an Italian restaurant and you now want to open a second location, that's fine. Like that's, within the scope of kind of what you were, contemplating doing with your E-2. Similarly, if you know that already that you have future plans for running different types of business lines, you may want to contemplate that in your initial 5-year business plan. It can kind of be tricky strategically in the sense that if you say you're going to start doing this within 1 year, they may want to see investment towards that. But it is something you can do if you say, hey, I'm going to offer software services. I've funded the company for that. But down the road, we're going to get into mobile app development. In year 4, we're really going to focus on that. That's fine. And now if your business goes in that direction and you come back for a renewal, you have the ability to show them, yes, that this was something we always contemplated. So you do want to kind of, again, discuss before you make any of these changes. We have, unfortunately, many people that come to us that just weren't aware, maybe that their E-2 was that limited. Maybe they've dissolved their E-2 entity and started a new one. That can cause major issues, so you do want to kind of just be mindful of maintaining your E-2 once you get it. And then business purchases from family members. So this, again, very common scenario. It is possible, to get an E-2 in this situation. However, they're going to be much more sensitive to whether or not this is really the fair market value of the business. So it's a good idea to have kind of an outside valuation, or at the very least have kind of a CPA who's maybe commented on the latest, tax returns or audited financials of the company, so that it makes sense, what you're, so, if you're paying $25,000 for a 50% share, but it's a very profitable business with lots of assets, lots of cash flow, lots of high revenues, they're going to look at that askance. So you do want to make sure you've done extra things so that they understand, yes, even though it's not an arm's length transaction, we do know each other. Ultimately, what I'm investing is the fair market value that anyone off the street would pay for this business. All right, so we've reached the end of time, and I think if we have any questions, we can answer them, but it looks like we have not had any questions come in. So with that, since we are at the hour, I will just say thank you to Hugues for sharing all of your knowledge. Thank you all for joining, and we hope everybody has a wonderful day. Thank you.